Hello, everyone. For my presentation, I am doing Regents of the University of California versus Bakke. This case was determined in 1978, and it revolves around desegregation. The University of California Medical School at Davis accepted 100 applicants into their program each year based off of competitive test scores and GPA. The school reserved 16 of those 100 spots for qualified minorities as part of the university's affirmative action program, long-withstanding to prevent unfair exclusion of minorities from the medical profession. Alan Bakke, a 36-year-old white male with exceedingly high and qualifying scores, put in an application 2 years in a row to the medical school. Bakke was rejected both times by the University of California. Bakke's qualifications exceeded the scores of any of the minority students who had applied and were accepted into the program. Bakke took his case first to the Supreme Court of California and then to the United States Supreme Court, claiming he was excluded from admission based solely on his race. Bakke argues that the University of California violated the 14th Amendment Equal Protection Clause and the Civil Rights Act of 1964. This case was argued in the United States Supreme Court on October 12, 1977, involving Regents of the University of California and Alan Bakke. The disagreement involved reverse discrimination, and Bakke claims his 14th Amendment rights were violated along with Title VI of the Civil Rights Act of 1964. The U.S. Supreme Court was responsible for determining if the University of California violated either of those acts. The 14th Amendment of the United States Constitution granted citizenship and equal civil and legal rights to African Americans and slaves who had been emancipated after the Civil War. After Reconstruction, Bakke does fall under the Equal Protection Clause, stating that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. The court also had to answer to the question of whether or not the University of California discriminated against Bakke under the Civil Rights Act of 1964. According to Title VI, this bars institutions that receive federal funds from discriminating on the basis of race. Based off of the arguments in question, the U.S. Supreme Court ruled in favor of Alan Bakke. The justices of the court were quite divided in the decisions. Out of 9 Supreme Court members, 8-1 decided and ruled in favor of Bakke, claiming Title VI of the Civil Rights Act of 1964 provides Bakke a cause of action. 5-4 decided for Regents of the University of California, stating that Title VI of the Civil Rights Act does not prohibit the university's race-based admissions program. 5-4 decided for Regents of the University of California under the Equal Protection Clause, permitting race to be one factor among many in an admissions program. And 5-4 decided for Alan Bakke under the Equal Protection Clause, prohibiting the university's specific race-based admissions program, therefore deciding that Bakke will be admitted into the medical school. Justice Lewis F. Powell, Jr. cast the deciding vote, ordering the medical school to admit Bakke. This decision was made June 16, 1978. Little did Powell know that he would be paving a way for future education regarding race and ethnic inclusion. The courts decided that the university using racial quotas in their admissions process was unconstitutional, but the school's use of affirmative action to include minority applicants was constitutional. This case changed the course of education. Schools became involved and acknowledged the use of affirmative action. The conversation about race and equality was transformed. This case changed how colleges recruit and enroll minorities. It's no secret that Ivy League schools were mainly populated by white people. To get beyond racism, we need to take race into account first. I don't personally agree with the decision of the court, but I understand the legality in the fine print. The idea of reverse discrimination is bogus, and I am actually in awe that this case made it all the way to the United States Supreme Court. The almost 50-50 split on the decision was disheartening, especially since the Civil Rights Act was only placed into effect 10 years prior. And this case did not protect minority groups striving for higher education. This case was decided in Burger Court, and in closing of this case, Warren Burger opinionated. In light of sorry history of discrimination and the devastating impacts on the lives of Negroes, bringing the Negro into the mainstream of American life should be a state interest of the highest order. He then proceeds to tell us that to fail to do so is to ensure that America will remain a divided society. In the future of education, this is an eerie reality that the fight is not over. Teachers need to push for anti-racism in their classrooms. I will teach to provide the tools for my students to become social justice warriors and be able to make decisions based off of facts and the rights that all humans deserve. Thank you very much for listening. That is the end of my presentation.